instead of this thing.
Yeah, yeah. So the reality is,
on behalf of the Rehnquist Center, welcome to our annual Constitution Day program. I want to give a special thanks to the people who work behind the scenes to make this program happen. Marissa White, Janet Keisinger, Nancy Stanley, and Paul Keeley, thank you for all your help putting this together. And I want to thank David Potts, our student volunteer, who's going to keep the panelists to the time schedule. I've been told, my only job here today is to introduce the panelists, and I've been told that the more important the person, the shorter the introduction should be, so my introductions will be very brief. We have Clint, who is Vice President for Litigation at the Goldwater Institute. He's a nationally recognized litigator who's argued and won cases in state and federal courts all across the country, including in the Supreme Court of the United States. Thank you for driving down from Phoenix. Sitting next to Clint is Judge Neil Wake, who's a United States District Court judge for the District of Arizona. Judge Wake, prior to being appointed to the bench, had an active litigation and appellate practice in Phoenix for about 30 years. He's a big supporter of the school, often participates in our Constitution Day programs, and thank you very much for coming, Judge Wake. To Judge Wake's left is Seth Waxman, who is a partner and chair of the Appellate and Supreme Court litigation practice at WilmerHale, Washington, D.C. He served as Solicitor General from 1997 to 2001 and has argued more than 60 cases before the Supreme Court of the United States, including one of the cases that we're going to discuss today. Thank you very much for making the effort to come all this way, Seth. And finally, filling in for Professor Dave Marcus, who usually performs this role for the Rehnquist Center on Constitution Day. And that's big shoes to fill, but I'm sure that our own Toni MASSARO can fill those shoes. Toni is a Regents Professor, Riepe Chair in Constitutional Law, Rehnquist Center Board Member, and former Dean. And she's going to moderate the discussion, and she has the unenviable task of having to summarize these cases before the panelists get to talk about them. So thank you, Toni. Thanks. And as a community, I'd like to just take a minute, too, to thank Sally Ryder. I mean, we have had a stunning series of programs over the years thanks to Sally's directorship of the Rehnquist Center and the high regard with which she's held. And so, Tucson, join me in thanking Sally for making these things happen year after year. If I were Dave Marcus, well, I'd have red hair and I'd be funny. I don't have red hair. I'll try to be funny a little bit, but not so much. This term, I'm going to preface it a little bit and then talk about the first big case. Everybody felt that what we were looking at was epic. What was happening here had the potential to be in the pantheon of the major cases of the court. And I think what happened certainly was important. It's certainly the case that Chief Justice Roberts ended up being the epicenter of whatever epic things happened here. And I'm thinking about just reading an article that's going to be the foreword to the Harvard Law Review, in which there's reference to the superb book about the LBJ years, in which they talk about how power or the office reveals. And the writer is saying that, of course, that's true at the court as well. Over time, the period on the court reveals who the court is. And there's intense interest right now, isn't there, in how the power and the office is revealing what we see in our chief. Here he is in his 7th year at the head of this court, and what we see unfolding are the following unsurprising but important characteristics. He holds to, as everyone expected, conservative legal principles. You bet. It's described as increasingly conservative in this way, not a particularly optimistic view of the potential of politics to serve best our constitutional values. A quote also from Pam Carlin's foreword. He also is described as a pragmatist. He was, from the beginning, during his nomination proceedings, described as politically savvy from his youth, as an incrementalist, as somebody who is committed to preservation of the institution he serves and to preserving what might be described as judicial capital. Willing to engage, as Jeff Rosen has written, in saving constructions, or even, in the term of Thomas Jefferson, derisively talking about his rival John Marshall, twistifications. But not afraid to engage in occasional sweeping principles. But in this case, I think some have argued, and I agree at least in part, John Marshall-like in banking judicial reserves, but spending them frugally, saving them for another day. Above all, I think he's described, sometimes people think of this in sinister terms, as a master strategist, and yet anyone familiar with the empirical literature about judges would know that this is an important part of what judges do. The characteristics of effective judicial strategizing include A, moving the law in the direction that their jurisprudential bent indicates is the best path of the law, and of course there's an ideological component to that, but also they have to be interested in efficacy. Will the people follow? Will the people obey these opinions? And by way of preface, I think, everybody knows what must have been in the chief's mind. These are efficacy, strategizing is inherently contextual and yes, political. Of course it is. We're all legal realists now. We're not afraid of those kinds of insights. So what does he do in these contextual times? He's living in partisan times. Robert Shirley is worried about many things, including the reputation of his court, the reputation of the government itself, and the barrage from right and left and different parts of right and left on judicial review itself. Most particularly, it seems to me, he has to deal with something that may be relatively new to our time, a division not unprecedented, but relatively more prevalent in our time. Not just a division between left and right, but a division between right and right. And so in his own constitutional ranks, those with whom I think he has the greatest affinity intellectually, there's disagreement about where to move, when to move, and above all, how fast to move. In the Affordable Care Act case, I think what's revealed is what he does in one of the toughest cases he's confronted thus far. It's a structural con law case, con law 1, if you will. And it did not steal upon an unsuspecting American people. Let me remind you of where this thing came from. March 23rd, 2010, President Obama, I'm not sure if he's left-handed or right-handed, signs the Affordable Care Act into law. Significant provisions include the expansion of coverage under the federal health care programs such as Medicaid. Second, the creation of new programs to integrate and reform health care delivery, such as Medicare Shared Savings Program. And here it comes, the minimum coverage provision. That will require, with limited exceptions, that individuals maintain minimal essential health care coverage as of 2014. And what do we call this? The individual mandate. And if you are non-exempt and you don't have insurance and you don't purchase it in 2014, here's what you're going to have to do: make a shared responsibility payment. Now, after the enactment of the Act, individuals, orgs, 26 states brought suit against the federal government. And in March 2012, we saw several days of oral arguments before the Supreme Court, and it boils down to 4 issues that the panel will address today, or some part of them. First, and this was one that I don't think people fully expected, justiciability. Right. Justiciability, well, we're lawyers, so we think that this is the most gripping part of the case, of course, right? But what it is ends up being really important to the claim of twistifications, at least to some extent. Normally, or at least under a statute passed by the Congress, the Anti-Injunction Act, if you want to object to congressional power or authority to issue a tax, you have to pay it, and then afterwards, object to it, essentially. That the courts can't step in advance. The second issue that the court had to deal with in this case, of course, was the individual mandate constitutionality. The third issue that they dealt with in the case was whether the Medicaid expansion mechanism that they set up was constitutional, and the final issue had to do with severability. As to the first, justiciability, just as a practical matter, how do you think they resolved it? Would this be on the program if they said, they decided they had power to do it. They decided they had power, notwithstanding the fact that the timing is early, in essence, because congressional intent under the statute was not to treat this as a tax, but as a penalty. And therefore, the Tax Injunction Act was not implicated, and the court could proceed which both sides wanted the court to do in any event. The big issue, here comes the thunder. Is the individual mandate constitutional? And as I've described in another setting recently, what happens here, I'm focusing less on any other opinion than the way the chief handled the issues. And what he does is he sets up what I call a constitutional Trojan horse. And it's very, this part, I think, I've said, I think John Marshall is somewhere tipping a glass and saying, well done, sir, well done. What does he do? You're the Congress, and here it comes into the gate, and you've passed this epochal measure, and here comes the court, and they say, here's your present, here's the horse. And you look at the horse, and you say, what have you given us? And the court says, we've given you power to pass the individual mandate, and you're extremely happy. On what basis do they have power to pass the individual mandate? And this is the surprise to some. They had power to pass the individual mandate as a tax. Didn't I just say that they said it wasn't a tax for purposes of the Anti-Injunction Act? Yes, but that was for statutory purposes, and always, or significantly, for assessment of constitutional power, nomenclature doesn't do all the work, says the chief. In any event, he secures a majority of the court to bring the horse into the gate and says, tax power, yes. The mandate could be sustained under the Congress's tax power. Basically, it's nothing worse than a tax because people subject to it may lawfully forego health insurance and pay higher taxes, or buy health insurance and what? Pay lower taxes. The only thing you can't lawfully do in 2014, if you're not insured and you're not exempt, is not buy health insurance and not pay the resulting tax. So saith the court. Step 2, it wouldn't be a Trojan horse, would it, if there weren't any Greeks? And here they come. Inside of the tax decision is the other coalition, the joint dissent plus Chief Justice Roberts. Not in one opinion, but together, if you count the noses, 5 justices essentially conclude what was argued by Paul Clement in his brief, and in the intellectual, sort of forefather of this, being Randy Barnett, and adopts jot for jot, really, the thinking and an argument with respect to the Commerce Clause objection that was advanced in those cases. And he agrees. And what's that argument? This is the one you probably know. Congress can regulate activity, but it can't regulate inactivity. It can't. What happened here, according to the chief, is the problem is that the broad, and he admits that it's broad, not one case is overruled. Not by him, not by the joint dissent, not by any of the opinions. He says, looking at this broad Commerce Clause authority, it presupposes the existence of commercial activity to be regulated. The problem with the mandate, he says, is it creates activity to compel individuals to become active in commerce by buying something, rather than regulating existing commercial activity. And what would be next? We will all have to buy broccoli. Okay. Now, consequently, this could not be upheld under the Commerce Clause. And in this respect, as I say, he adopts the argument and the thinking of former Solicitor General Clement, and then he does something else. So you've got the Trojan horse, tax power, yay, inside, watch out, no Commerce Clause, no, and inside they're the Greeks, and now you say, now just how big are these Greeks? And the chief's opinion says, maybe not so big. The Greeks, in there, the Commerce Clause restriction, think of trying to teach it or outline it. What is the caveat to the Commerce Clause that we can actually say was introduced in this case? On the one hand, it's really significant that 5 members of the court, for the first time since the 1930s, concludes that a social welfare piece of legislation is unconstitutional. This is big news. On the other hand, he says, look, as the brief argues, and as we've been saying, this is an extraordinary assertion of power. Novelty doesn't doom. It doesn't doom something Congress does, but it does give one pause. And he looks at the other examples of regulating inactivity that were suggested by Justice Ginsburg and says all of these were predicated on different constitutional powers. They then turn to the possibility, well, look, this is a big measure. You've got Commerce Clause arguments. Even if they fail, could we say the necessary and proper clause somehow resurrects this and enables Congress to regulate inactivity in order to secure an effective regulation of an indisputably commercial activity, this healthcare market. And here he again adopts the argument of the briefs on that side and says no. It would be an extraordinary ability to allow the Congress to basically create the predicate necessary to the exercise of its power in what may be described as bootstrapping. And this would compromise the federalism balance, though here I don't think he elaborates so much on exactly why, other than if you don't have the power, by definition it invades the states. Okay, so that's what they do. It's Trojan horse on this individual mandate, but it's upheld. Inside is, we'll see where this goes in the future with this potential caveat. The last two parts, I can go through somewhat more quickly, and yet the third part was to me the stunner. Of everything they did, I think this one surprised me the most, for what that's worth. I'm easily surprised. And here we see displayed more, I think, directly the judicial philosophy in service of an end, but it's not just 5 justices. Here the justice gets 7 of them. 7 of them. And this is often lost in the news accounts that it wasn't Chief Justice Roberts and his, describing them as conservative cohorts, but it was also Justice Breyer and Justice Kagan who conclude, for the first time ever, that a congressional spending measure is unduly coercive of state power. The Medicaid funds medical care for needy people through a federal and state partnership. Federal government gives matching funds to states that say, yes, we're going to agree to apply with your requirements. This new measure in the Affordable Care Act, the amendments, the expansion, would greatly expand the number of covered individuals. People who are at newly eligible people beginning in 2014, income up to 133% of the federal poverty level. But, depending on your perspective, the federal government, in saying we're going to expand to this previously underserved or not served population, this coverage, we're going to fund it. Not partially, we're going to fund it. 100% of the expansion is going to be paid for by the federal government through 2016, with the federal share going down to 90% by 2020. And also built into it is a kind of take it or leave it approach to this. In other words, your on-board a Medicaid program is going to morph over time, and you're in, and the condition of receiving the funding will be continuing to change your behavior to comport with the ways in which it morphs. But this expansion says you buy the expansion or not. If you don't buy these terms, you lose all your Medicaid funding. And that is you're in a whole lot of trouble, Haas, because that is just a huge amount of money. And an aspect of this is the hugeness of it. An aspect of it also, though, was the fact that it was the new expansion. And an aspect of it was that the idea that one person has called this anti-leveraging principle, that you can't just say it's a lot of money, that's all that was doing the work here. You have to look at the amount of money and the nature of the program and the newness of this expansion and the way in which Congress set it up. And they say, no, that goes too far, and 7 thought it went too far. But here, maybe the ultimate twistification, one that enraged, I think, the joint dissent, was that the court concluded, a majority of the court concluded, that the Medicaid expansion conditional spending, take it or leave it, whole hog approach was unconstitutional, but it snipped around rather than throwing the whole thing out and preserved as much of it as it could, which one might say was judicial conservatism in not invading legislative autonomy, or could describe as twistification that becomes a form of judicial activism, and that was the struggle within the court. So this is what they did with Medicaid funding. The new program is protected, but this condition that you lose all the money is not, and they sever it. And that answers the fourth question, is this a take it or leave it the whole act? If any part of it is unconstitutional, do we have to throw the whole Affordable Care Act baby out with the bathwater? And the court says no. Bottom line, where are we at? It's justiciable, it's constitutional, except for this piece of the Medicaid conditional spending measure, and it is severable, and we ask ourselves, what does this mean tomorrow? And that's why we have these programs, and that's why professors have jobs. We don't know. We can tell you all provisions of this act now continue to be in effect with some limits on the Medicaid expansion. Con law implications, I've told you, and I'll tell my students, it's a Trojan horse. We'll see. As far as C.J. Roberts, he was excoriated for strategizing in this way by some. He was celebrated by others, but I do have to say, I think that the analogy to Marshall, at least in part, was an apt one in this case, and I do think that somewhere the chief is toasting him with a nice glass of Madeira.
Good afternoon, everyone. I am Clint BOLICK from the Goldwater Institute. I want to say to Dean MASSARO, what a great kickoff, and my kids would absolutely, who are 7 and 10, would absolutely have loved your talk because you used on repeated occasions their favorite word, which is epic. And in fact, I can now report that this decision rises to the level of LMFAO, which is also epic. But at least in their eyes. But also a very brief commercial announcement for those of you who are law students and interested in constitutional law and of a libertarian or conservative philosophy, please consider clerking at the Goldwater Institute. We do some very cool stuff, some of which I will talk about over the course of our discussion of the 3 cases. For those of you who happen to be parents of law students, send your kids our way. And for those of you who will neither be interested in clerking or have kids who are law students, please send money. So moving rapidly, I have a few observations, and what I plan to do with my time on each of these cases is to not try to do a comprehensive analysis. Dean MASSARO did a great job on that, but just to make a number of observations. Not surprisingly, the Goldwater Institute was very strongly opposed to Obamacare and was actively involved in the legal effort to challenge the law. And a lot of conservative or libertarian critics are really, really upset with this decision, but the optimist that I am, I really do view it as a glass half full or maybe even more than half full decision, despite the twistification. I love that word, and I am going to embrace it in my legal advocacy henceforth. In which Chief Justice Roberts engaged. You know, I honestly think this was probably the most predicted decision in terms of people weighing in on what they thought they were going to do. I am unaware of anyone who predicted the exact outcome of this case, despite the myriad people who weighed in on it. Certainly no one predicted the split on the various issues in this court. And so that's pretty remarkable, because usually, you know, you can predict the outcome with some degree of probability, and I don't think anyone did here. But certainly a decision in which is predicated on a program being a tax for one purpose and not a tax for another purpose is very, very difficult to pull off. It's constitutional under one provision, but not under the other. When you put all those things together, it truly was a tour de force. But the 2 things that I really loved about the decision were, first of all, the incredibly important decision that individual inactivity is not regulable by Congress under the Commerce Power. And secondly, and I'll talk a little bit about this further later on, the decision on federalism, that states cannot be coerced through the spending power into specific types of activities. What is terrifying about this, so many people have looked at the arguments advanced by Randy Barnett and Paul Clement and said, wow, these are radical arguments that Congress's power is limited under the Commerce Clause. And that just shows how screwed up this country has gotten over 200 years, because what is really radical is the notion that Congress could possibly regulate a person's inactivity under the Commerce Power. And what is terrifying to me is that 4 members of this United States Supreme Court believe that that is true, and they are 1 vote away from a majority. If that principle were to be adopted, there is no limiting principle on that power. Today, I would not have been an outlaw in the city of New York because I did not purchase a big gulp. Fortunately, here in Arizona, we still do have that choice, but I abstained from doing that. Did that affect the economy? Absolutely, it affected the economy. Should I be compelled, or should the government, should Congress have the power to compel me to do that? I think in a free nation, absolutely not, and under the commerce power, limited as it was, to regulate commerce among the states for the purpose of preventing the parochial trade wars that were going on among the states. That was a major force, a major impetus for adopting the Constitution. That was intended to be a very limited power. So I think that the fact that 4 justices of the Supreme Court really voted to fundamentally transform our federal government from a government of limited powers into one of literally unlimited powers it's astonishing and a very, very scary notion. And for that reason, I think that we dodged a very serious bullet in this decision. Now, one question that worries conservatives is there now a schism on the court? Dean MASSARO, I think, accurately depicted Chief Justice Roberts as having a very well-developed philosophy. Is certainly not disappointed conservatives in a variety of cases from Second Amendment to federalism and on in the past. But it was very interesting and very worrisome to see that even where the 4 conservative justices, dissenters on some issues and supporting the court's opinion on others, did go their own way and really walled Chief Justice Roberts off. Does that mean that Chief Justice Roberts is the new Anthony Kennedy or the new Sandra Day O'Connor as a swing justice? Have absolutely no idea, but there is a case coming up this term where I think we will find out, and that is the affirmative action case out of Texas. Previously, Chief Justice Roberts, very hardcore on the issue of racial preferences. We'll see. That could give us some indication of whether he has shifted. I don't think so. I think his principles are too strong, but we shall see. I do think that the 7-2 decision on the Medicaid expansion was a really, really important decision, and I was shocked to see 2 liberal justices support that. I am calling this part of the decision the anti-Darth Vader rule. You may remember that Darth Vader made the proclamation at one point, "I am altering the terms of the deal. Pray that I do not alter them further." That is, of course, the position that Congress, and I can kind of picture Congress as Darth Vader in many instances, probably some of you may as well. That is the position that Congress played in this context. We are going to give you lots and lots of money for a voluntary program. The states all join in, and then Congress says, we are going to fundamentally change this program. We are going to dramatically expand states' obligations under this program, and if you fail to comply, we will take all of the funding away from you. The court has tiptoed to the point where it got in this decision in the past, but it has never come this far as to rule that that is unlawful or unconstitutional coercion, and that Congress cannot alter the deal to that extent. And I think this is a very, very important ruling for federalism. This is a part of the decision that I actually think will be the subject of more litigation than any other part of the decision, because the commerce power is one. Obviously, there are lots of Commerce Clause issues, but the issue of inactivity has not come up before. The tax power, not all that much. In fact, if Congress had to admit that this was a tax in order to pass the healthcare program. It might not have done that. So the thing that I think will actually be a very frequent subject of litigation in the future is the federalism component of the decision. Another point, there was a scary line in Robert's opinion that I think will map out future litigation related to Obamacare, and almost no one has picked up on this line, or no one possibly. He noted in striking down the individual mandate under the Commerce Power that the federal government, of course, can offer funding to the states, and he said, and I quote, "These offers may well induce the states to adopt policies that the federal government itself could not impose." There, of course, he is talking about the individual mandate. Now, what could he be referring to? What he is referring to is the adoption of state health care exchanges under Obamacare, which are funded by the federal government and subject to the regulation of the federal government, which could be used to create an individual mandate on a state-by-state basis, with the states actually taking the action to do so with the funding of the federal government. So what may happen is that we will get an individual mandate, but it will be done in that indirect manner rather than directly through Congress. So that gets to my final point. What are the future frontiers in terms of litigation on the health care law? That is one of them, and that is state health care exchanges that would impose an individual insurance mandate. 10 states have adopted a constitutional amendment that was drafted by the Goldwater Institute and was passed here a couple of elections ago, called the Healthcare Freedom Act. And it forbids an individual mandate or taxes that are assessed to compel or to coerce an individual mandate. 4 more states are considering the Healthcare Freedom Act this fall. We have an ongoing lawsuit, Coons versus Geithner, which is before one of your colleagues, and fortunately not the judge who is with us today, because otherwise I wouldn't be talking about this. But a case called Coons versus Geithner uses the Healthcare Freedom Act to challenge the federal program, but if the states adopt state insurance mandates, this will be a shield against a backdoor individual mandate. One other issue litigated in that case, and I suspect other cases will be challenging it as well, is another feature of the federal health care law, a very benign sounding agency that was created by the federal health care law called the Independent Payment Advisory Board. Obamacare created a number of federal agencies. The Congressional Research Service was asked how many agencies did it create. They did a study. They went through every page of the bill, unlike the members of Congress, and they came up with an answer. The number of agencies created by the federal health care law is unknowable. Well, one of those agencies, the Independent Payment Advisory Board, which comes online in a couple of years, has the mandate and the power to essentially restrict health care costs, to contain health care costs via Medicare. Their mandate to do so and their powers to do so are virtually unlimited. There are 3 aspects of this agency that we believe in combination make it unconstitutional. A, its actions are essentially unreviewable by Congress, and that was intentional because Congress doesn't want to have to cut back on Medicare expenses or doctor reimbursements or services that are provided by Medicare. They want this agency to do it, and they don't want to be implicated. So its powers are essentially unchecked by Congress. Second, its actions are unreviewable by the judiciary. And third, it is unrepealable by future Congresses. If you've ever seen that before, let me know, because we believe this is an agency without precedent and yet it is a linchpin of this federal program. Stay tuned. This battle is not yet over. Thank you very much.
Well, first, some comments about the Commerce Clause issue. This debate has been overtaken by people attempting to simplify the question in ways that are intuitively persuasive for their side. And here I suggest both sides start with different intuitively valid principles and then stretch them to apply to the grayer areas of this case. And I suggest to you that perhaps both sides are basically right on their main focus. The Chief Justice starts with the powerful premise that if compulsion to buy is regulation of commerce, there's no limit to the Commerce Clause power. And they reason that the health insurance specifically market does not escape from that principle, and perhaps driven by their powerful aversion to the idea that forced buying is regulation. Justice Ginsburg exhausts a different perspective of the specific effects of lack of insurance on the health care market and health costs and financing. From that powerful beginning, she concludes easily that this is about commerce, obviously so, and it is at least within the range of debatability that requires recognition of Congress's power. And though she says she disputes the validity of the Chief's premise that forced buying is not regulation, her real thrust is that such a limitation would be inapplicable here. And the undisputed fact and consequences of free riding in the healthcare market and financing, which may exist in other places, but probably not to the extent and with the dramatic consequences as it does in the healthcare market, is the premise that renders leads her to reject the generalized rule that forced buying is not regulation as governing this case. As I said, I suggest in a sense both sides are right from where they start. Forced buying to stimulate the economy would have no endpoint. We're never going to be forced to buy cars to subsidize GM. And even forced buying for your own good, it's better to eat broccoli than cookies, collapses into the truism that all conduct or even absence of conduct is measurable in terms of the human exchange, and so has an economic dimension and crosses state boundaries. A power to enforce buying in that general sense looks like it would be equivalent to the general police power to require or forbid conduct. And I suggest the Chief Justice has it right as a starting point that forced buying should not be justified under the Commerce Clause for those purposes. But that baseline insufficiency of forced buying should not necessarily taint it universally as a potential means of addressing serious problems of genuine commerce. And I also submit that Justice Ginsburg has the better of it, that forced buying in the health insurance industry is plainly remedial of a grave commercial problem of the financing of health care, and is probably essential to any reform of our health care financing short of a single-payer system. Now, where would you draw a line on that? There has to be some measure of gravity to the commercial problem, and not just implausible hypotheticals about improbable situations. And bad faith invocation of the Commerce Clause to effect what is really police-powered choices are easy to smell. The Affordable Care Act has no scent of that at all. The insufficiency of forced buying as a justification of exercise of Commerce Clause power has a logic that is useful in general. But the force of logic can attenuate in the face of increasingly different facts and more facts. so that the general logic must yield to a new logic that takes account of those different facts and additional facts. And I submit it as a matter of judgment, not of the internal logic of the syllogism itself, when to step back and restructure the syllogism to take measure of the additional facts. And I also suggest that health insurance and health care financing are inherently integrated, even though the Chief says otherwise. Now, let me offer this comment. I'm going to suggest that the significance of the court striking down of this individual mandate in general, whether you think it's dictum or not, is unlikely to have a lot of practical effect, in that Congress is unlikely to attempt more of this. They are responding to their perception of a nearly unique problem. I also want to offer some comments specifically to our students here that this case is a rather dramatic example of differences in approaches to advocacy. The challengers articulated this issue on a high level of generality that has a strong appeal to many people, including me. And they appealed to judicial duty to apply that principle at a high level of generality. And of course, was asked to strike this down out of duty. And the defenders pressed the powerful circumstances of this specific case to structure a rule that captures those intuitions to what they see as the right outcome. Now, let me just say briefly about the tax and power argument. First, it seems to me entirely sensible that Congress should be able and recognize as exempting from its own law, the Anti-Injunction Act, something by not calling it a tax. This is just legislation, and there are reasons of policy and tax administration not to allow interference with collections. But when Congress called it something else, that ought to be enough to say our Congress's other law is not invoked. And I suggest the Chief does have it right, that although there is no truth in legislating clause of the Constitution, they didn't tell the people what they were doing, that doesn't limit the power of Congress and the duty of the court in addressing the substance of what they did. Now, I suggest that I agree with Clint entirely. The real force of this decision is the spending power decision. Congress in recent decades has shown that it will take actions without regard to the effect on states as governments. Back 50 years ago, Herbert Wechsler wrote an influential article, The Political Safeguards of Federalism, in 1957, in which he suggested a diminished need for judicial enforcement of constitutional limitations on congressional power at the expense of state power. The same voters elect both federal and state officials, so democracy itself should restrain Congress and prevent the destructive encroachments on state government. And this seems intuitively right, but a half a century of experience has proved Wechsler spectacularly wrong. Not for every Congress, but for enough Congresses. I suggest a superior principle that can be observed in the conduct of Congress is that power has a huge gravitational force that sucks in more and more power. It is not a criticism of Congress, but an observation of human behavior and political behavior, and we see exactly the same behavior in with state law and state government actors. Now, briefly on the merits of it, the withdrawal of all Medicaid funds as a sanction for not joining the expansion is unprecedented. It would bankrupt many states. It would eliminate any meaningful policy choices by the states that require expenditure of money. So far, the court has been very reluctant to intrude in this area, but what we've seen is overreaching by Congress. This one is not an incremental reach. This one was really astounding. So it is not surprising to me that the court finally said, we have to signal a willingness to scrutinize these carefully, and this goes too far. Of course, there's no bright line test as to where the measure will be, but at least it is signaling to Congress that they need to start thinking to some extent about what these constitutional principles are. Let me say one other thing. I'm going to disclose my personal political views. I personally think, and not to persuade you of anything, but for full disclosure, I personally think the Affordable Care Act is doomed to failure. It cannot possibly succeed unless the objective is to move us into a mode where there is no choice but to move to a single-payer system. So I hold no brief for this statute. Those are my comments.
First of all, I want to express my appreciation for being invited to Tucson and to an event to speak on Constitution Day. I'm just delighted to be here. I know that it took me, I traveled many more miles than everybody else in this room all put together to get here. But it's worth it. It's a real honor to be here. And I hope the next time I come to Tucson, I can stay for the weekend. So I did not participate at all in the Supreme Court litigation on the Affordable Care Act, you know, for a party or on behalf of an amicus for reasons that I would love to tell you but can't disclose. And I don't, you know, I have to say that I have been skeptical about the general outlines of the provisions of the Affordable Care Act that we're talking about here ever since they were first proposed by the Heritage Foundation in response to, you know, Democratic proposals to reform health care. And I guess it's not that I don't ever agree with the Heritage Foundation about anything. In fact, I've done volunteer cases with them. I'm on the same side as them, but it struck me as wrong as a way to solve the healthcare problems. But because I'm not a healthcare economist and don't really have an opinion about it, I guess I'll just disclose my own bias up front that I don't know whether it will or won't work. I know that we have an unbelievable problem in this country with access to affordable health care, and the status quo ante was clearly unacceptable. I hope this will work. If it doesn't, I hope Congress will have the power to do something that will work. But my comments today don't really relate to the bona fides of this law or not, but instead, in honor of Constitution Day, to sort of discuss the opinions of the justices of the court, you know, in light of where this takes us constitutionally. I want to say that I quite agree with Clint on this and probably precious few other things.
But they are precious.
They're precious to me too. I also agree that the Chief Justice's opinion is an overwhelmingly conservative opinion that happens, a thoroughgoingly conservative opinion, that happens to get to a, quote, liberal policy result if the Heritage Foundation's proposal can be called a liberal policy result. Certainly the Chief Justice's opinion for himself, but well aligned with the joint opinion of the 4 joint justices, that the universal coverage provision goes beyond Congress's power under either the Commerce Clause or the Necessary and Proper Clause is a breathtakingly conservative position. The court's opinion, the Chief Justice's opinion for 7 justices that the spending clause authority is unconstitutional is landmark because, as has been mentioned by the other 2, it's never been done before. And it's certainly consistent with conservative principles of a restriction of Congress, the federal government's authority under the spending clause to spend for the general welfare. You know, the part that immediately got deriders of the law all upset is that the Chief Justice found that the universal coverage provision, which is also inaccurately called the individual mandate, but I'll get to that when we talk about this provision, is constitutional, is that he found that Congress had the authority to do this under the taxing power, because he found that this actually, although Congress assiduously refused to call it a tax, in fact operated just like a tax and therefore was constitutional. And I don't view the, choosing up sides on whether you determine whether something is within the taxing power for constitutional purposes by what Congress called it or by how it actually operates as necessarily either a conservative or a liberal thing. So I really think that what we have is an unalloyed conservative decision in this case, as I said, that happens to ratify the Heritage Foundation's inherently liberal policy objective. What impact this decision is going to have either on the course of constitutional jurisprudence or on social and economic policy, I think is quite unknowable. And I think actually might depend importantly on who wins the election in November. Because on the one hand, one can say, and I quite agree with the comments that preceded me, that the rulings about on the Commerce Clause, the proposition that Congress can't regulate inactivity. It's not regulating inactivity to make somebody who isn't doing anything, do something. Probably isn't going to happen very often. I don't think it happened in this case for reasons I'll explain, but it's unlikely that Congress will be in the business of going out and regulating inactivity. We know from the Spending Clause decision only this, that this provision, the undisputed provision that when Congress exercises its authority to spend for the general welfare, that authority extends more broadly than Congress's ability under its other enumerated powers to compel citizens or states or other entities to do something. That is, it has to be a carrot, not a stick. All we know from this decision is this uniquely coercive provision is too much. The court expressly refuses to set out even any guideposts as to what about it was too much. Is it that it was so much money, or that it involved essentially a retraction of funds for a pre-existing program, or both, or something else? We just don't know. And there will be plenty of constitutional litigation, good news for people like me and Clint, and probably Judge Wake as well, because the cases are interesting in light of this. But I don't think we really have any idea whether the principles that are enunciated or the constitutional results that are enunciated here will actually have legs or not. It might very well depend on the next half generation of Supreme Court justices. And when I said it depends on who wins the election, I'm just guessing that the next president will probably have the opportunity to appoint some new Supreme Court justices, not that anybody on the court appears to be tottering off or storming off. And the composition of the court could well determine whether some of the euphoria on the conservative side and fear and loathing on the liberal side comes to pass at all. Similarly, from the policy perspective, my guess is that the principle of universal coverage and entitlement to universal coverage is likely to become part of the social compact of the country if the principles of this law or something that might replace it stay in effect. And therefore, if Governor Romney wins and succeeds in getting Congress to essentially overrule these provisions, that before they get a chance to take root in the national psyche and national culture, that'll be one thing. If it stays in effect and people get used to a rule in which they have a safety net, they can choose not to exercise it if they want to pay a tax, but they can't be denied coverage because of a pre-existing condition, and even if they get insurance because of a pre-existing condition, can't be charged so much that no one other than a successful private equity manager could afford it. may very well become just part of the accepted wisdom in the way that things like school desegregation and lots of other innovations in our constitutional history have come to be. I'll say just a couple things about first the Chief Justice's opinion and then each of the, well, three of the principles that Toni articulated. The Chief Justice's opinion has a lot of anomalies in it, and not just the ones that were mentioned earlier. Both of the prior speakers talked about the anomaly of something not being a tax for purposes of the Anti-Injunction Act, but being a tax, although it wasn't called a tax, for constitutional spending clause purposes. And I agree with Judge Wake that the Chief Justice did get this right, and it's thoroughly defensible. But nonetheless, his work is highly redolent of an observation that then Justice Rehnquist, and this really is on point, it's not just because this is the Rehnquist Center, then Justice Rehnquist once observed in an early dissent about the majority opinion, which is that the reasoning in that opinion, I don't have the exact quote, isn't really reflective of the work of Hale, Holmes, or Hughes, but rather Houdini. And, you know, at an even moderately superficial level, it does sort of seem like a aha moment for the public, which is we can adjudicate this because it's not a tax, and having adjudicated it, we uphold it because it is a tax. The Commerce Clause section of the Chief Justice's opinion is surpassingly odd because it wasn't necessary to his ultimate conclusion that the law is constitutional, and ordinary principles of judicial conservatism with a small c, you know, absolutely stand against the principle that you should decide constitutional issues that don't have to be decided. Now, the Chief has explained himself in his opinion that the thing more naturally seems to be a Commerce Clause power, and he would have ruled that way but for having to convince himself that it wasn't. That may be, and I believe it is, a truly accurate representation of his thought processes. It doesn't make it a holding rather than dicta. The other anomalous thing about the Chief Justice's rationale is that he strikes down the mandate because it is a mandate to an individual to do something that the individual wasn't doing at all. That is, it was an individual mandate of compelling activity from somebody who wasn't engaged in activity. And yet it's upheld under the taxing power as a tax on inactivity. And you know, I have found the need to think about this for a long time to figure out how those two things could be true, could both be true if in fact they are. I also want to suggest that the real objective to what's called the individual mandate, which I think for reasons explained in the Chief Justice's opinion in the taxing clause section, is not an individual mandate because the law doesn't require you to buy health care. It just says for those people who choose to avail themselves of the health services market without the ability to pay for it through insurance or otherwise, you have to pay a tax, just as people who smoke cigarettes and therefore impose health care costs on the rest of the tax-paying public, disproportionate with their share, have to pay what I can tell most of the cost of a pack of cigarettes is in fact federal taxes, and this is quite similar to that. The real objection to what's called the mandate is an objection that stems from personal liberty, economic liberty, the idea that the government doesn't have the authority to make us do things that we're not doing unless it has a surpassingly exigent need to do it. And yet, this law was never challenged by anybody, as far as I'm aware, in any of the litigation on liberty grounds under the Fifth Amendment of the Constitution. And that was, it seems to be quite striking in view of the animus against the mandate, the animus against what's called the individual mandate is this interferes with the personal inviolable liberty that each of us has. Now, the consequence, of course, of challenging it under the Due Process Clause is that there is also a Due Process Clause in the 14th Amendment, and if it is a violation for the federal government to impose this mandate, inconsistent with individual liberty, individual states couldn't do it either, and nobody, so far as I know, was willing to take that argument on. But I find the most remarkable thing about this is the public objections to this, and in many ways the basis for the constitutional objection to it is not that this is not regulating commercial economic activity. It obviously is, but that it goes a step too far in that it impairs a fundamental precept of individual economic liberty, and yet you don't find any of that in the briefs of the parties or the opinions of the court. That said, with all those anomalies in the Chief Justice's opinion, I think it is quite a good opinion. It's a good opinion for the court, and it's a good opinion for the Chief. And in fact, I wrote a piece for Time magazine the day after the decision came down, which they published in truncated form, and without the title that I gave it, which is A Chief Justice Looks to His Legacy and the Courts. And I think that's very much what the Chief Justice had in mind, and I don't think there's anything wrong with it or one needs to be apologetic about it. As I said, I realize that we have very little time left, and am I about to get the red? You've got like 12 minutes. Okay. I think the Commerce Clause arguments strike me as wrong, as I said, because I think this is manifestly a statute about economic regulation, and it is a regulation of commerce. I mean, as the Supreme Court made clear, since everybody's invoking John Marshall, I'll invoke Gibbons versus Ogden, which made clear that Congress has the power to regulate commerce. This isn't about regulation of persons in commerce. As I said, I don't think this is a mandate because it is not against the law not to buy health insurance. It's against the law not to pay a tax if you don't, just as it is not against the law to smoke cigarettes. I also think that there really is, I mean, if one thinks about it, the principle that the government shouldn't be allowed to compel activity from one who chooses inactivity has a lot of power from a different provision of the Constitution. But I don't really think that what we have is inactivity here. I mean, any more than was the case in Wickard versus Filburn. The problem with what Wickard was doing was not that he was growing his own wheat. The Congress's objection to what he was doing is he wasn't buying wheat in the national wheat market. And the Supreme Court upheld Congress's authority to make him do that. Now, is that the inactivity of not buying wheat, from a wheat dealer, or the activity of growing his own wheat? And we can debate this forever, but it's very, very similar to what's going on here. Everybody is participating in the health services market. Some very few people, none of whom I know, have made it to any point in their life where they actually have never seen a doctor or a paramedic or needed to go to an emergency room or anything like that, but it is sure as shooting that we almost all will have to. And I thought one of the interesting concessions of the challengers of the law was that it would have been perfectly legal for Congress to have written a law that said no health services will ever be provided, can be paid for by any means other than insurance. That is, if you're going to be involved in the health services, health care market, you can only pay for it with insurance. That would be constitutionally unobjectionable. That seemed to me to give up the whole game because we're all doing it, and now we're just talking about timing. As to the necessary and proper clause, again, I'm not sure that the court's ruling here is going to have very many legs, but I do think that the analysis that the Chief Justice goes through is wrong. He agrees that the legislation, what's called the individual mandate, is necessary. it's manifestly necessary because mostly what this bill was about was providing the option for affordable health care, which meant that we can't have a pre-existing conditions exclusion, and we can't have individual rating rather than community rating. Otherwise, the people who most need health care will be least likely to be able to buy it. And the enactment of the so-called individual mandate, whether it's a mandate or not, was certainly a necessary means for financing and making stable, or we'll see whether it is or isn't stable, to have a prayer of being stable, those two critical provisions, that is, the pre-existing conditions and the community rating provisions. And so it was clearly necessary. The Chief Justice's analysis that it's not proper is, it's not proper because it's not a valid, it goes beyond what Congress can do under the Commerce Clause. Well, the whole point of the necessary and proper clause, as Chief Justice Marshall explained to us in McCulloch, is that Congress has the authority to use means that go beyond the means that are specifically permitted by the enumerated powers if it is necessary to achieve the end. And the limitation, and I take significant issue with Clint's argument that if this thing stands, and the dissenters are right, there are no limits on what Congress can force people to do. The limits on what Congress can do are written into the Constitution in the form of guarantees of individual liberties and negative prohibitions, and that's why I find it, from a constitutional perspective, so frustrating that nobody on the court engages with the textual limitation that, however one would decide the case, most naturally restrains Congress from doing what it did, which is, as I said, individual and economic liberty. And there is an external thing, but neither the Chief nor any of the justices in the joint opinion advert to that. And I think, unless one is willing to haul that out and examine it as a negative prohibition, it seems to me this is within Congress's power under the necessary and proper clause. As to the tax power, I've already suggested a couple ways in which the decision seems quite anomalous, which is it's taxing inactivity if you believe that there was inactivity here, which seems A, passingly peculiar, and B, if it really is taxing inactivity, then this is a direct tax under the Constitution and therefore invalid because it's not appropriately apportioned among the states, because nobody really quite knows what the scope of the constitutional provision on direct taxes is, but we do know that it include capitations as opposed to decapitations, which we're told are taxes on living, a tax that is applied to every living person in the country just for being alive. And if this, it seems to me that if this is a tax on inactivity, and it must be, according to the Chief Justice's rationale, must be a direct tax, even though nobody has seen anything that they thought was a direct tax in a very long time. There's a big debate between the dissenters and the majority over whether this is a tax or a penalty. And it sort of seems like a penalty because it seems clearly designed to achieve, to influence individual behavior. And I think you'd have to be crazy not to think that that's the case. It's designed to encourage early participation in the insurance market so that those of us who do participate and do pay taxes don't have to pay for the uninsured down the road out of our own pockets. But Congress and the states have been passing taxes to encourage individual behavior since the beginning of time. And I think it's probably wrong to consider this a penalty for the reasons that the Chief explains. Really what we have here is a sin tax, like cigarette taxes. Congress is saying here, as it says in the cigarette area, Here is a form of behavior that we are not going to step in and mandate has to be stopped or started. You have to stop smoking. It's illegal to smoke cigarettes. Or you have to stop freeloading without insurance and the ability to pay on emergency health care services and other hospital procedures that our society otherwise feels impelled to allow you to have, even if you can't pay for it. All we're saying is that if you don't stop this activity or inactivity, you have to pay more taxes so that the people who are blameless and shouldn't have to shoulder the tax burden don't have to shoulder as much of that burden. Finally, on the spending clause, I think everybody was surprised that the Supreme Court granted cert in this case. I know that Paul Clement was too, because he told me. I think that the Supreme, and I know there's been a lot of furor about the two of the, quote, liberal justices voting with the conservatives on this. If Medicaid works the way everybody seems to assume it works, it doesn't offend my sensibilities at all to say that this really does amount to coercion. I mean, my first reaction to this when the Supreme Court first granted cert is, this is like a heroin addict, or somebody who started out on whatever, marijuana and then increased to hashish or whatever the progression is, complaining that he's being coerced when he's offered heroin or more heroin. I mean, it's like, please. But I do think that there is something about this that that the case has been made that the states have become so reliant on the overwhelming federal contribution to the Medicaid systems, to their individual state Medicaid systems, that they simply could not. This was an offer they couldn't refuse. And an offer that you really can't refuse is not really an offer. It's an offer that you can't refuse. What's really disturbing to me about the opinion is two things. One, it relies heavily on United States versus Butler, which is a 1936 opinion that was quite promptly overturned by another case the court cites often, which is the Stewart Machine case. But this was, an early New Deal case back at the time when the Supreme Court, the conservative justices in the Supreme Court were striking down all the New Deal legislation. It was promptly overruled, and I feel like it's disturbing that so many justices are relying on United States versus Butler, which struck down the Agricultural Adjustment Act, as authority for anything. I also think that the court's reliance on Stewart Machine for the proposition that they don't have to say what makes something too coercive as opposed to a spending offer, is really disturbing. It's one thing, as in Stewart Machine, to say there's a limit. We're not going to say what the limit is, but this is constitutional. We will let this provision go into effect. It's quite another thing to say there's a limit. We're not going to suggest to you what the limit might be, but this is too much. It's much the same as I think Judge Wake would feel if the Ninth Circuit issued a summary affirmance of his decision as opposed to a summary reversal. That is, we're just going to say, so obviously wrong, we're not going to explain in what respect. Anyway, there's a lot to see in the future on the policy and the constitutional grounds, and I'm as excited as the other panelists to figure out what it's going to be.
So we have a 15-minute break, and if you're not back in time, you won't see the pornography.
Wow. This is
Okay.
I'm first.
We're going to move from the structural con law case that dominated people's attention to one that might have been a big one but tended to escape some attention, including the courts in a way, FCC versus Fox. Freedom of expression. The Roberts Court has gotten a, in many ways, deserved reputation of being a very pro-free speech court, on the one hand. Think of the funeral protest case, the recent Stolen Valor case, Citizens United itself, and a number of other cases which seem to be speaking in a voice of real triumph for freedom of expression. There's another part of the story. Dean Chemerinsky has talked about this, cases in which the speech is occurring in non-traditional public fora, cases in which the speech is by government itself, etc. In these cases, it's decidedly less protective of speech. And then there's also, and in the workplace additionally. Then there is also sort of the curveball that's been there for a long time with respect to freedom of expression in the court's doctrine. And this extends well before and likely will extend beyond the Roberts Court. The court is squeamish about, historically squeamish about sexually explicit expression. And when those little pitchers with big ears are around, that would be minors, it worries about the parental right to control what their kids hear when they are in places where it's understandable that they might want to control those messages at least to some degree. What do we do about it? It's played out in the arena of broadcast media by allowing the government, the federal government, the FCC, to adopt regulations that the government could not possibly adopt in full public fora. Because in the full public fora, the broadcast media, we have this bromide that says we're not going to drag down the level of consumption of First Amendment discourse to that which would be appropriate to minors. So that's on the one hand. But on the other hand, there was the George Carlin case. You know, the filthy words of George Carlin broadcast during the afternoon, the parents driving down, turns on the radio, and oops, there they are. And it was with not enough time for the parent to avert the child's ears, throw the kid out of the window, or otherwise prevent the exposure to the words. This has continued to be an agonizing problem for the FCC. On the one hand, the court approves of a certain zone of otherwise protected First Amendment activity, indecency, vulgarity, nudity, etc., expletives, that couldn't be regulated on the street corner, F the draft, Mr. Cohn's jacket, right, that can be regulated in the broadcast media, at least with respect to certain hours. Okay? And yet, we've got cable now, we have all kinds of other technology that sort of maybe undermine the force of the claim that we really need the persistence of this exception. So there we thought we were. 4 things happen. 1, Fox, 2002, Cher. You gotta love Cher. Okay? Everybody's always ruling out Cher. Her career is over, her career is over. She gets up there and said, people who thought my career was over, and she's on the Fox channel, well, F them, okay? My mother might be watching, cut me a break, all right? 2003, Billboard Music Awards, Nicole Richie. And they're up there making jokes about some TV show that I've never seen that has called The Simple Life. And she says, The Simple Life, have you ever tried to get cow out of a Prada purse? It's not so simple. Okay. No penalty imposed because not apparent that Fox could be penalized for this at the time of the broadcast. Throughout, we're worried about notice, vagueness, and then we're also worried about, even if you have notice, is this the kind of speech that can in fact be regulated? Later incident. Bono, God love him. 2003, Golden Globes, he gets an award, and he says, this is effing brilliant, okay? This leads to the Golden Globes order in 2004, and the FCC is trying to clean it up and make more clear to them, and they've had a changing guard there in terms of their attitude about whether to act on this authority to regulate vulgarity, fleeting expletives, brief nudity at all. But they look at this and they draft in 2004 the Golden Globes order. And they make clear then that the F word is actionably indecent. And they reverse prior rulings that fleeting expletives are not indecent. And they say any use of the word is inherently sexual. And describe the F word as one of the most vulgar, graphic, and explicit descriptions of sexual activity in the English language. But no penalties imposed. Finally, and here it is. Thanks to, I'm blaming him. Thanks to General Waxman, you can't really understand, I think he's absolutely right, understanding the case, let's see what happened. Let's see what happened. NYPD blue, giving whole new connotation, double entendre to the word blue. And that was that. I told you it was fleeting. wasn't not a problem, as it turns out. Though that episode, 7 seconds long, during prime time, resulted in a penalty of $27,500 forfeiture on every station that aired the scene, $1.24 million. Rather than drill into the holding, I'm going to turn it over to someone who knows a great deal more about it, Mr. Waxman, to talk about the case. Mr. Waxman.
I'll take that as applause for having forwarded to Toni the clip, which I told her, you know, we're obviously going to have a really interesting 3-hour discussion, but this will punctuate it with a lot of human interest. So, I mean, just by way of context, what wasn't shown in the clip, right before the clip starts, it's the beginning of the episode, there is a 15-second interval where the screen says, parents caution, the following scene contains, you know, nudity, violence, et cetera, you know, parents are strongly cautioned. I'm not sure I've actually ever met a parent who then got up and who was otherwise inclined to watch a show that was in its 11th season, where the very first episode of NYPD Blue involved the male lead, Detective Sebelius, naked in the shower, which apparently was such a crowd pleaser, although in my own imagination at least, it seemed like a horrifying scene, was so popular that he was routinely showed naked over the course of many seasons. But in any event, this, the Fox ABC case, as it came to the Supreme Court, was really 2 cases. There was the FCC decided that these fleeting expletives, as it's called, were actionably indecent, although because it acknowledged that it was changing its policy with respect to fleeting expletives, which had never before been sanctioned, it announced that it was not going to fine Fox, and it would not ever use this to count against Fox in license renewal or in any other respect. The ABC case, the ABC was the original lead defendant in the expletives case because of another episode of NYPD Blue. And my mother isn't watching, so I will not be using, well, it didn't involve the F word anyway. But it was a scene in the precinct house where Detective Sebelius, who was this sort of crusty old, New York City homicide detective, gets some eager young trooper comes up and says, we've broken the such and so case. I've got a witness who says X, Y, and Z, and Sebelius says, who is it? And he gives the name, and Sebelius says, that's bullshit. That guy is a dickhead. And the FCC, after 4 years and 11 months and some weeks after the complaint about that episode, delivered itself of an opinion that the use of the word dickhead was unobjectionable under the FCC's own definition of indecent speech, which is, by the way, speech that depicts or describes sexual or excretory organs or activities. Dickhead somehow was not a word that was used to describe any of that, but bullshit, the commission said, was, even though so far as I know, it doesn't depict or describe certainly any sexual activity, and as I pointed out to the Second Circuit immediately, the only excretory activity that reflects is the product of bovine excretory activity. In any event, as soon as we challenged this in the Second Circuit, the FCC went running to the Second Circuit and explained that they would like the court to remand the case to the FCC because they wanted to consider the matter further, and they thereafter, quote, discovered that none of the complaints that were made about this show were made by people who had seen it in prime time, but people who had seen it during the 11 o'clock safe harbor hours. So they told the Second Circuit reluctantly they would be unable to proceed with this as their lead case about why the FCC's rules about what is or isn't actionably indecent on broadcast television couldn't be adjudicated, and that's how Fox came to be the lead case. I mean, the Supreme Court's decision in FCC versus Fox and ABC is, it is significant in certain respects for what it said. It's very, very significant, as Toni was suggesting, for what it doesn't say. The principle, there were two constitutional objections to the FCC's order, and in ABC's case, the fine. One is the First Amendment simply does not allow the government to proscribe that speech when we are in an era in which television is no longer, quote, uniquely intrusive into the home. Cable, I mean, no one even knows at this point whether they're watching a cable network or a broadcast network through their cable or satellite service, and there are no restrictions whatsoever on cable. So this would be tame and probably not generate enough ratings on HBO and SHO and many of the other non-broadcast channels of television. And also an era in which there are parental warnings, and in which we have, Congress has mandated that all televisions above 13 inches or above have the V-chip, and this was coded to, this episode of scripted television was coded to be blocked by the V-chip. And therefore, the First Amendment argument to the notion that the government can proscribe and criminalize that shower scene display, which occurred in the context of a multi-episode exploration of the awkwardnesses and challenges of blended families. I mean, Detective Sipowitz's wife, that was his son. His wife was murdered, and years later he fell in love with another detective whom you've seen in all her glory. And the show was exploring, you know, how you actually, the awkwardnesses of a blended family. And so the first time these cases went to the Second Circuit ruled on administrative law grounds. Just so that you know, I was representing ABC, not Fox. Our administrative APA challenge to this was that buttocks are not a sexual or excretory organ. They are, to use the medical dictionary, the fleshy part of the rump, which covers sexual or excretory organs. You can imagine how fun it was to have an oral argument about that. In fact, when I did argue the case in the Second Circuit, I sort of went right to the constitutional arguments, the First Amendment and the Fifth Amendment argument, which is the basis on which we won. And the presiding judge in the Second Circuit, who I will not name for his own, out of deference to his personal privacy, at some point in the middle of my argument says, Mr. Waxman, you know, the very first part of your brief is, you know, an argument about legal definitions and whether this is actually even covered, and I expected you to be leading with that argument. And my law clerk and I have viewed this scene many times, and we have a number of questions about this. And I said, you know, Your Honor, I think everything that could possibly have been said about this anatomical, definitional argument and many things more have already been said in the briefs. And he said, well, nonetheless, I want to ask these questions about it. So I got dragged, kicking and screaming into this definition of whether what you saw was a sexual or excretory organ. Anyway, the Supreme Court decided it on APA grounds. The Second Circuit decided it on APA grounds. The Supreme Court granted the SG's petition to hear the case, the Fox case, and on the grounds that this was a narrow APA, this was an APA case, but it nonetheless had terribly important First Amendment implications. When it got to the Supreme Court on the merits, the Solicitor General was running away from any First Amendment part of the argument, and the Supreme Court reversed the Second Circuit, saying the FCC gave plenty of explanation for why it was changing to a fleeting expletive or fleeting scene, and therefore there's no APA violation, go back. On remand, the Second Circuit said this violates the First Amendment like in 20 different ways. The SG then petitioned for review in both cases on the grounds that that was wrong. And as it came to the Supreme Court, there were two arguments. One is this violates the First Amendment, at least, as I was arguing, with respect to scripted television that is fully blockable by the V-chip. And second of all, this violates the Due Process Clause because the proscription, that is, speech or images that are, quote, indecent, as defined by the FCC, is so vague that nobody knows what the FCC will or won't punish and what is or isn't okay. And we cited the court to instances where there were minutes, not just fleeting seconds, of nudity, including full frontal nudity, that the FCC had adjudicated complaints about and which it had found were, quote, fleeting. One of the interesting, and as those of you who've read the opinion know, the Supreme Court did not decide the First Amendment question at all, even though it is overripe for decision. I think doctrinally and in light of this Supreme Court's First Amendment holdings, not just in the cases that Toni articulated or discussed, adverted to, but even in the indecent speech cases like Reno versus ACLU and Ashcroft versus ACLU, this doesn't come close to the line of what the Supreme Court is saying has absolutely protected under the First Amendment expression. But there is no decision on the First Amendment. The Supreme Court, and there's no decision on what was our principal void for vagueness argument, which is you look at the FCC's definition, nobody knows what indecent means. The FCC has tried to define it by saying, in context, it's, offensive to general community standards because it displays or, depicts sexual or excretory activity. And these terms, these definitions are so vague and so broad that, number one, they don't provide notice, and number two, they allow for arbitrary enforcement. And the FCC's standard ought to be struck down. The court says we're not going to decide that question either. All we're going to decide is that when it went to this so-called fleeting enforcement policy, there was inadequate notice to the parties. So Fox and ABC had no way of knowing that the FCC would change its enforcement policy to deal with these fleeting instances of profanity or indecent images. It raises a lot of questions. First, why is it that they didn't address the First Amendment question? It's really important. It doesn't seem that controversial. I think there are basically two reasons, and one Toni adverted to, which is there just is a general unease, not just among the justices or the conservative justices of the Supreme Court, but all of us, really, about the implications of what the Supreme Court has said under no uncertain terms the First Amendment allows. Right? I mean, really, the First Amendment under the Supreme Court's doctrines does not permit fining somebody because Nicole Richie, comes up with some unexpectedly stupid and vulgar reference. I mean, why were people watching Nicole Richie? On the other hand, if you say, well, look, this doesn't apply to cable, it doesn't apply to the internet, it doesn't apply, and this is just not that offensive given, what kids learn on the school bus. And there's a V-chip, and, parents can decide not to let their kids watch this thing. So does that mean you could have a scripted television show that's like the nude shopping hour, where people just walk around in supermarkets, naked for an hour? I mean, I think that actually the appeal of that would get old quickly, but the implications of definitive First Amendment ruling are disturbing to a lot of us. The other reason is that Justice Sotomayor recused herself in the case because she'd been on the Second Circuit as it was bouncing up and down, and she didn't sit on the panel, but there were many petitions for rehearing en banc. And it may be that given how unsettling a constitutional ruling is on this, the court decided that if it could avoid it at all, it would. Now, avoiding big constitutional questions and avoiding big First Amendment questions is, with all due respect, not something that the Roberts Court has been particularly fond of. I mean, in the Citizens United case, it was as broad a ruling as you can get, and the court itself had to pose the question because nobody had raised a First Amendment issue in the litigation all the way up through the Supreme Court. The breadth of the Supreme Court's First Amendment ruling in Humanitarian Law Project versus Holder is truly breathtaking. And this one doesn't seem like it's that broad, but I do think it's because it does involve a subject matter that many people are just not comfortable with. And there was the prospect, absent Sonia Sotomayor, of a 4-4 split in which the Second Circuit's result would be upheld by an evenly divided court, was just unsatisfying. The grounds on which they did decide it, the void for vagueness doctrine, I'll just say two things and then three things and then sit down. As I said, even there, it's a very narrow decision. It doesn't talk about how unbelievably vague the FCC's, quote, standard is. It's also sort of curious that the court even adjudicated the Fox case, right? I mean, Fox wasn't sanctioned. The FCC said, we know we've changed our policy, and for that reason, there will not now or ever will be any adverse inference taken from this. We're just using this opportunity to state that these kinds of fleeting expletives are actionable. And so, I mean, why did Fox have standing to raise the void for vagueness due process objection at all? This was something that we discussed with Fox's lawyers a lot, and in the end, we just decided that ABC had a completely unproblematic void for vagueness problem because we were fined $1.25 million for this. The final thing is that the court's void for vagueness doctrine traditionally developed in the criminal context. That is, you can't criminalize conduct where the legislature has not spoken pellucidly clear about what is or isn't allowed. This is a case in which there were, even in the ABC case, just a fine, and in the Fox case, nothing. And yet the court is applying the void for vagueness doctrine to strike down the government's sanctions and regulations. And while it is true that void for vagueness has been applied in civil cases before, and I think properly when the government acts, I think that the court's decision in this case has potential legs for other forms of regulation and adjudication. I mean, one thinks about hostile environment and sexual harassment workplace cases where, a company is found liable for a lot of money because an employee was using totally inappropriate language in the workplace. I mean, I think that's the right result. It's the right policy result, but I'm not sure that any of these companies have really due process notice about what they do or don't have to do before they yank somebody who's made an off-color remark or put up a really obnoxious photo in the workplace to just fire them or risk the prospect of huge sanctions. So that's what I have to say about the case. It was a really fun case to litigate.
So we're tight on time. They each have 5 minutes, and then we're going to go to the SB 1070 case and hope that we can conserve some time for you all to give feedback to the panel.
I'll go. Actually, Judge Wake asked to go next, and the judge's motion is granted.
Well,
Well done.
I throw out a threshold question of what is the social utility of this language? And suppose I were to say to you about this program here, this is a big effing deal. Would you think, A, that I am articulate, B, that I am persuasive, or C, that I'm a Rahm Emanuel? So now...
I don't think we would think any of those things.
So, and General Waxman, with respect to that question about buttocks, I was a little surprised to hear that an advocate of your stature would respond with the oldest evasion there is. It's in the briefs. So, you know,
I didn't put it that way, but I should have.
well, I thought you would have said at least it's not covered and it's in the briefs. So, but anyway, I will use less than my 5 minutes. The other thing about the retroactive character of this was just obviously dispositive. And one has to think about, well, if the court would have gone ahead and answered this question of whether Pacifica is out of date, they would clearly be subject to renewal of the withering criticism that they got in Citizens United for reaching out and deciding an important constitutional question. And the question of, you know, whether that is an interesting question, I don't claim to have any expertise in it, and I would always also pose this question of, is there an impossible tension here between a vagueness and precision? That you have a vagueness concern about punishing people for something that clearly is speech, but on the other hand, is it even possible to restrict the coarsening of the public media? And the answer may be, oh, it's not possible, we're going to give up. And the answer might also be that, hey, our culture has already coarsened, so we're just going to catch up with the culture by abandoning this exercise. I don't have the answer, but I yield to Clint.
Well, we now have an example of something that rises to the rarefied level of one of the precious few things on which Seth Waxman and I agree emphatically on this case. And, you know, some of the things he didn't say make this case even more amazing. For example, the FCC's policy in 2004 is that the F word, which I also will not utter because this could be connected to a radio station and it is prime time. So the F word is per se indecent because it always has a sexual connotation. Now, I am going to make an admission here that I have never made before, and that is that I occasionally do use the F word in all of its glory. When we get an adverse decision from a court, for example, I often use the F word. And when I am describing the court in that context, I am not using it in a sexual way at all. So I know that emphatically not to be true. The other thing, another thing that the FCC found was that exhibiting buttocks, quote, clearly panders to and titillates the audience, end quote. And, you know, on that one, I also have to say it really depends on whose buttocks. And aren't you supposed to, if you were a television station, be pandering to the audience? You know, I mean, that's what you were in business to do. But I could not, I not only agree with the court's decision, but I also agree with Seth's frustration that this was not decided on First Amendment grounds. And in fact, Justice Ginsburg notes at the end that she wished that the Pacifica Doctrine had been reconsidered. It actually disturbs me that no one joined that very brief concurring opinion, because Pacifica, which was decided in 1978, was based on a technological set of circumstances that utterly and totally does not exist today. So if that decision was correct in 1978, it certainly is not correct today. However, because I am currently litigating a case on vagueness grounds involving bus ads in Phoenix, I am really grateful that the court did give us a really terrific decision on vagueness, which we instantly submitted to the court as supplemental authority. So thank you very much, Seth Waxman.
Okay, teeing this up takes a little time, but this is a case that needs not that much introduction here, given that Arizona was and remains the eye of the legal and the political storm. Nor did the Supreme Court case striking down significant portions of SB 1070 end the controversy. As you know, in early August, freedom riders began a drive to draw attention to continuing civil rights abuses, and Sheriff Joe's law enforcement tactics still spark both spirited support and sharp condemnation. Other jurisdictions have mirrored the Arizona law, and in this election year, the result of this case and the ongoing controversy about the matter continues to divide the American people and to be a high-level political issue. But in fact, the case that the court decided last year with respect to SB 1070 was pretty technical. It dealt with preemption. They did not address the civil rights issues in that case. It was a facial challenge, which ends up being important, and it involves the intricacies of immigration law and policy. With preemption cases, the devil is always in the details, and there are very few people, and I'm not one of them, who's an expert in immigration law and policy. Everybody emerged as an expert on immigration law and policy when the case began its journey, but in fact you need to know a lot about it to figure out the nuances of preemption. Here's the deal. Arizona says we passed 1070 with the stated purpose of achieving attrition through enforcement, by which it clearly meant cracking down on lawful entry into the United States by undocumented persons through the southwest border. And it said, look, Arizona has a 389-mile border with Mexico, and it's porous. And we have, by some estimates, 285,000 undocumented persons here. And they further argue that we suffer a disparate impact by virtue of the presence, an economic and public safety impact by virtue of the presence of undocumented persons. And it is the failure of the federal government to adequately police the southwest border that has prompted this otherwise perhaps unnecessary state response. They also say, look, the states have police power, traditional police power, and they may be exercised to protect state interests provided the state's action observes legitimate principles of federalism. And look, what we did here, we did nothing but mirror, in one case, federal law, and it's a form of cooperative federalism here. We're helping the federal government implement this policy, and we're working together. That also, this is proven, they said, by current federal laws that both expressly and impliedly anticipate state law, cooperation, enforcement activity to support federal efforts to regulate immigration. Therefore, they complied with the federalism constraints. The federal government responds, no. At least with respect to these 4 provisions, you went too far, 2 of which have to do with status and 2 of which have to do with new crimes in the state of Arizona. How did they go too far? Well, congressional intent is to control relevant aspects of immigration policy that are either you're producing an obstacle to or conflicting with, or we've occupied the field. And basically, the Supremacy Clause of the Constitution already decided about the balance of power in cases like this. And what did they say? According to the federal government, it has trumping power where it A, has the power to act, and B, is given either exclusive power over the subject matter, or C, the federal government has chosen in a legitimate realm to act and has done so in a way that divests, elbows out by express conflict design or implication, conflicting or otherwise obstacle-forming state laws or policy. Neither party denied the first point. Nobody denies that the federal government has constitutional power to act in the area of immigration and naturalization. Contrast that with the Affordable Care Act, where the question was, do the feds have authority to act in the first place? Nor did either party deny that the states have police powers that interact with federal government powers. Naturalization may be an exclusive federal power, but the field of immigration law and policy is much broader than naturalization per se. And in the latter area, concededly, the federal government over time has expanded, as it has in other areas, its regulatory arm. And as it's marched out, what we see is more federal law in the field, where otherwise, in the absence of federal law, there would be only state law or no law. There's more than there was in the 19th or the 18th century. So this is a hard question, and a threshold question. Did the expanded federal power in the area of immigration law and policy bump out the states? Did it displace? And what the states have done, did the states obey the supremacy clause here? Did they merely complement in a cooperative federalism way? Or did they challenge? Is this a mirror or a magnifying glass? Now, what exactly has the state of Arizona done here? Well, it didn't help its case by any means by starting out with, it's our intention to achieve attrition by enforcement. It's like an opening declaration of what they intended to do, and the way in which the two governments interacted make it difficult to see much cooperative federalism going on, at least from an emotional level or a political theatrical level. And also, as it turns out, it ends up being a problem at the more granular legal level. 4 challenge provisions. Judge Bolton in the federal district court, as part of this larger piece of legislation, she thought that all 4 of the challenge provisions were preempted. The Ninth Circuit Court of Appeals upheld her over a very strong dissent. The case gets to the United States Supreme Court, and you have again, I think, an example, and you have one justice who's recused, and so the risk again of a 4-4 decision in an incredibly controversial area. You have some crossover, or a perceived crossover here, Justice Kennedy and Chief Justice Roberts, and with respect to at least one issue, Justice Alito. Okay? What is the conclusion? I think you know this, but unanimously the 8 uphold the show your papers provision, the first provision that was challenged. This provision is not preempted. Show your papers. Any person, so-called, any person who is stopped or arrested or detained by the police in Arizona for any purpose must be held by the police until their status is verified, if the police have reasonable suspicion to believe the person is undocumented. The second provision is another status verification provision, Section 6, 5.3. This is deemed to be preempted, not upheld. The police may do a warrantless arrest of anyone where they have reasonable suspicion that he or she committed a public offense that makes them removable from the United States. And then the other 2 also are deemed to be preempted. The only one that the unanimous court upholds again is the show your papers as not preempted. New crime, and this is important, I think, Justice Alito agrees, this is 6-2. It is preempted. What the state could not do was adopt a new crime that it would be a crime under state law to fail to register under federal law, but exempting anyone who can show official ID documents like your driver's license. And then finally, there was another new crime section, Section 5, making it a crime for an undocumented person to engage in unauthorized work. The court gives its rationale for these things with respect to Section 2 not being preempted. They say that in this case, the government, as long as the government has a legitimate predicate for the stop, that's independent of the fear or apprehension or the belief that the person is undocumented. And they say at the level of facial challenge, we are not going to presuppose bad faith at this point, but leave open the as-applied opportunity. They have a legitimate, non-preempted state power to stop, arrest, or detain. And after the stop or arrest, once that predicate power is properly assumed, then they can go on to engage in the investigation as long as, says members of the court, you don't delay them longer than you normally would, though the investigation into status can continue after the stop. They say police already can do this. This is just merely demanding it. They say federal law encourages state and local officials to contact the feds on this. So we're going to approve this, but you come right back. If you can come up in an applied case of illegal equal protection type discrimination that's operating in this space. With respect to Section 6, a warrantless arrest if you have probable cause to believe a person has committed a public offense that makes him or her removable, not okay. This is preempted under obstacle preemption. Now basically here the majority says this gives Arizona officials more power than trained federal officials, trained immigration federal officials. And it's not, as a general rule, a crime for a removable alien to remain present in the United States of America. Quote, states can cooperate in detention and ID of removable persons pursuant to a 96 law. But, says Justice Kennedy, no coherent understanding of the term cooperate would incorporate the unilateral decision of state officials to arrest a person, an alien, for being removable absent any request, approval, or other instruction from the federal government. Arizona, you went too far. Third provision, the new crime, makes it a crime to fail to carry valid immigration papers while in Arizona. No, just to carry it at all. 6 of them say, look, if there's an older case, Hines versus Davidowitz, field preemption operates here, and we're going to crowd you out here, and this is just not permissible. And to the extent that you are arguing that all you're doing is mirroring this theory of state authority, they conclude is too adventurous. Finally, Section 5, the second new crime, makes it a crime to work without federal authorization. This is struck down by 5 justices on grounds of field and obstacle preemption, where they take an existing federal law that has a comprehensive scheme with respect to employment, and they say they specifically chose not to impose this type of criminal penalties. Silence was not inadvertent. You can't just fill it in. The omission is telling and was intentional, and the state cannot fill in and basically modify that prosecution authority or civil authority by adding crimes where they didn't exist, where the federal government in a legitimate zone of its authority chose not to act. In closing of my remarks, Kennedy's final remarks, I think, are worth noting. The national government has significant power to regulate immigration, and with power, he said, comes responsibility. And the sound exercise of national power over immigration depends on the nation's meeting its responsibility to base its laws on a political will informed by searching, thoughtful, rational civil discourse. I will leave to Mr. BOLICK the unbelievable dissent written by Justice Scalia, writing for himself alone, in which Justice Scalia, once described by the Wall Street Journal as delightfully brutal, is exceptionally scornful. And again, we'll try to keep you guys so that we have at least 15 minutes at the end for the audience, if possible.
Do we want to start with Neil on this?
That's fine.
Oh, I beg your pardon, yes.
Just
Sorry. Thank you.
I do like to talk the students in our audience, so I have some comments that are more focused on some really lawyering considerations about this case. And looking at this from the perspective of the state, and I don't know who the lawyers were, but if you were the lawyer advising the state, and the state here is your political clients and their objectives, the lawyer's job includes advising clients on selecting goals to pursue, on strategies for achieving those goals, reducing downside risks of the course of action, and you address whether the identified goals have enough chance of success to warrant the effort, the value to be achieved from the course of action you advise the client takes, and what contributes to success and what does not contribute or even impairs the chance of success, and how you might end up not better but even worse off. Now, the goals of the political actors in this case are clear, is to assist in reducing the presence of illegal aliens and workers in this state, and there are clear effects on that. I had occasion some years ago in a different case to have a hearing on evidentiary matters with expert opinions on the effect of illegal workers in Arizona, and this is on data 4 or 5 years ago. And I concluded very conservatively, resolving every doubt conservatively, that there was probably at least a 15% depressing effect from the presence of illegal workers in the state. At that time it was 400,000 or 500,000 estimated. Depressing effect on the lowest cohort of workers here, and that is people who do not have a high school diploma. There's also public expenditures, education of children who are not legally supposed to be in this country, health care paid for by the public or hospitals that is passed on to patients, crime. The state reports that there's both crime prevention and corrections costs. The state reports a disproportionate number of illegal aliens in the State Department of Corrections, and the perception is that there is a low level of federal enforcement. So there is, I think one would have to acknowledge, there's been a pretty vigorous effort, especially by the current administration, on border enforcement. But there's not much effort on employment enforcement. the jobs magnet largely remains, and that's not the subject of our discussion today, but in my view that is built into the Immigration Reform Act of 1986 that made it very difficult for the government to do much about employers who employ illegal aliens. So the challenge, if you're a lawyer advising state actors here, would be how the state could aid in effective enforcement consistent with federal supremacy in areas of federal preemption, whether direct conflict preemption or field preemption. Of course, field preemption doesn't tell you what it is, because you can have a broad field or a small field. You just still call it field preemption, and defining what it is where all the rabbits get stuffed into the hat. Now, the outcome here, as Professor MASSARO described, every one of these provisions was struck down except one, which, by the way, was the most important one, the issue of having to carry your alien documents. And by the way, Professor MASSARO, you use the phrase, show your papers, to refer to a different provision, but most of the time in the discussion, this show your papers phrase has been used to describe this obligation to carry your illegal documents. Making it a crime to seek or have work is preempted. Mandatory arrest of people who thought you have probable cause to think they've committed a deportable offense is excluded. The one that's left standing is the requirement for police who have otherwise stopped someone, who have reasonable suspicion to think that the person may not be legally in the country, to inquire on the immigration status. Now, this was the issue upon which Judge Bea dissented in the Ninth Circuit, and I believe there was a contrary decision in the 11th Circuit, and this is the issue on which the court upheld the statute, at least as against a facial challenge. Now, this, frankly, is pretty easy. There is a statute right on point that says the government must respond to inquiries from state or local officials about the immigration status of anyone. It's hard for me to see how you make a preemption argument when Congress has decided the government must respond to these inquiries. The argument that, oh, this is a burden on us is right to your congressman. It's in the statute. And there's another parallel provision, Section 1644, that says no one can prohibit authorities from making those inquiries. So you have an area here that looks like a direct, literal carve-out that authorizes inquiries about immigration status of anyone. That's all that was left standing, and that I think was probably the most important one. Let's look at the rest of the turnout. It gets worse for the state. You had arguments here, as in any preemption case, about the scope, maybe the mood music is the way to put it, about preemption. There is, in fact, a fair bit of judgment or even discretion in the courts in addressing these numerous questions about preemption from state statutes. It seems like it's taking a big part of the Supreme Court's docket in recent years. And one can come at it very narrowly, as Justice Scalia did in his dissent, or very broadly, as the court did in Justice Kennedy's opinion. And they took an expansive view of preemption in these areas or sub-areas, except for the one area that seemed to be, to me at least, to be covered by direct statutes right on point. So what we have now is a decision from the court that very seriously and in tone as well was dismissive of these efforts by the state. And it gets even worse for the political actors in the state who were pursuing their view of appropriate public policy. There's a dimension in this case that is, I think, potentially very significant, and that is historically preemption is a matter of the supremacy clause. It is what is the effect of the statute or occupying the field, and it is a dimension of the supremacy clause, and it is a matter of really of constitutional law, and it comes from Congress. The way it's set up, it's supposed to be hard to pass federal laws. You have to have a simultaneous bicameral majority to do it, And if not, the default position is state law. It was set up that way. It wasn't supposed to be easy. You're supposed to have all that. But it comes from legislation. The court put significant emphasis in this opinion on the fact that the current administration of the executive branch objected to a lot of this. It was their current policy. And they almost likened it to prosecutorial discretion in criminal law, where we're very used to the idea that criminal prosecution is inherently executive. It's not subject to any control. Yet this immigration law is an area in which Congress has extensive laws, including extensive laws, by which the executive branch can leave people in the country. But what we have now is this discussion that says because there's this general policy difference from the executive branch, that I can't say exactly how much, but it seemed to carry real weight with the court. That I can't help wondering about as to whether that is a significant change in preemption analysis and structure. And when you come to the executive branch discretion, there are really two kinds. Well, one is that typically what we see in criminal prosecution, it's not the only reason for decisions not to prosecute, but it's limited resource allocation. There's only so much that can be done. It becomes a policy judgment of where to devote your resources, and you cannot do everything. I don't think anyone would quarrel with that. But what we see here, and this is in a different way is the subject of this really strident dissenting opinion by Justice Scalia, is what you would perhaps uncharitably call executive branch nullification of legislative policy. The executive branch has decided that they are not going to enforce laws and not follow the procedures available to them to leave people, to exempt people leaving the country, but they just don't agree with the law. Now, the opinion doesn't discuss it in quite this way. They talk about it as executive branch discretion. So I would suggest that the outcome of this litigation was really truly bad for the people who started this initiative trying to achieve something. It appears to me that they ended up with a lot less than they had to begin with, because to begin with they had clear statutory authorization for the inquiry about immigration status. Now, of course, the court didn't get to the question on the facial challenge of whether when you detain someone too long that's a separate problem. That just the court really could not appropriately address it on a facial challenge, and one can infer what would likely happen if the police are holding people beyond a reasonable time in connection with what is otherwise a lawful detention with that, and one may think that the police will be trained to be careful to guard against that. So if you look at the strategy, I put this out. The first question you would advise your client is, what is the most value to you in pursuing the objectives you want? And by virtue of my work as a district judge, seeing a huge volume of cases involving people who are prosecuted for illegal reentry, almost always because they've committed crimes when they're previously in the country, maximizing the state assistance and identification of people who, where the identification is incidental to other appropriate detention, is the lowest cost, highest value to be achieved there. What had been going on in Arizona is that whether to make those inquiries was a matter of local discretion for each city or law enforcement jurisdiction, because there was no state law that dealt with it. And in fact, we had in Arizona what sometimes referred as the amnesty cities, where they'd made a decision to not make these inquiries, that people are not allowed to do it. The effect of the statute is to eliminate that local option and make it mandatory to make these inquiries. This looks like an ordinary act of municipal law. State law deals all the time with what matters are left to cities or counties, and what matters they cannot make their own policy on. So as an immediate issue, that was a benefit to be achieved from the people who had this policy view, and that does stand. It survives this decision. But these other terms, I suggest, had much less potential value to achieve these objectives. And they had a lot more risk of turning into racial profiling or even harassment, and they significantly increased the risk of loss of this litigation. So you wonder, if you're a lawyer thinking about cost, benefit, and risk analysis, what would you tell your client as to how to write this statute if you're representing the Arizona political officials? And there is a tone in this opinion that those of us who live here understand why it's there, that there seemed to be a style in this statute of confrontation with the federal government, not of assistance, but even getting in their face. Now, it's not for me to say whether that sense is justified or whether that frustration with lack of federal enforcement is justified, but it's not good legal strategy to say you're going to take on the federal government and dare them it's twisting the lion's tail, and you might end up getting eaten. So looking at all this, I must admit my 30 years as a litigator come up, and these thoughts really come to the forefront for me. Thank you.
Well, the Goldwater Institute does not get involved in immigration issues, so some of the comments I'm going to be making are my own, and this is actually an area of great personal interest. I am currently co-authoring a book with former Governor Jeb Bush on immigration policy that will come out next spring if I actually get it written. And so I am really, really interested in these issues. We have been, and this I guess may to some appear to go against form, we have been ferociously critical of the Maricopa County Sheriff's Office's law enforcement priorities, and so we this does certainly bleed into that a little bit. I was very interested in Judge Wake's comments on this, and Judge, you were the trial judge in the employer sanction case, right?
Yes, I was.
Which obviously gives Judge Wake a really, really great perspective, not only on measures that Arizona has taken with regard to immigration, but also preemption, which was the issue in that case as well. But Judge Wake's comments were very interesting because about executive action, very interesting, and I think that this issue may come up very soon. This case did present an issue in which the state was frustrated because it perceives the federal government is not doing its job. The more recent issue is, I think, even more overt, and that is President Obama's recent policy with regard to the DREAM Act. And that it happens to be a policy with which I agree, except that the president imposed it unilaterally as the president under the facade of law enforcement discretion. But when you look at this, this is a law that he unilaterally adopted. It is not a law enforcement discretion policy, and it sets up all sorts of new procedures and so forth. So the question that Judge Wake asked, which I think can be translated into, is if the executive takes unilateral action or inaction, and in this case, essentially adopting a policy that Congress has rejected, is that entitled to the preemptive force of federal law? And I suspect that there will be states, and it would not surprise me in the slightest if it was ours, who test that proposition. It's a really, really interesting issue. I think that the decision as the Supreme Court handed it down was correct. And the dean mentioned that I would say a word about Scalia's dissent, which Judge Wake also did, but Scalia takes the position, and this is a very interesting position, that Congress does not have plenary authority over immigration policy. I think all of us kind of started with the baseline that it does, but Scalia challenged that, and if you look at the actual words of the Constitution, Congress has authority over naturalization. And the word immigration is not mentioned there. And Scalia mentions that the states actually were the primary regulators of immigration in the first several decades of our country. However, no one shared his opinion that states have widespread sovereign authority over immigration. I was especially struck by the fact that Justice Thomas did not join him. If I were reading that dissent and did not know who wrote it, I would have guessed that it was Thomas, not Scalia, writing that, because it's Thomas who almost always goes into original intent, textualism, and that sort of thing. And I would love to know why Thomas did not join that opinion. It's a very interesting one, but it is clearly a position of one justice. I wanted to spend the rest of my time on this actually putting this case into the broader context. I don't think that there is any area of law in which the Roberts Court has had a greater influence than federalism. And this case is somewhat of an outlier because it by and large went against the state. But in a series of decisions that the Roberts Court, following on the Rehnquist Court before it, has taken a very narrow view of federal preemption in a whole host of areas, beginning with a case a decade or so ago involving the so-called Oregon right to die law, which the Bush administration claimed had been preempted. And the U.S. Supreme Court said, and this is interesting in the context of the recent decision, health care is traditionally a state function. We will not lightly infer an intent to preempt state autonomy in this area. And the court upheld the Oregon statute. It upheld Arizona's English-only law against a preemption challenge that then Attorney General Terry Goddard thought was so hopeless that he refused to defend the law. Then Superintendent, now Attorney General Tom Horne, defended it successfully before the United States Supreme Court. A case in Texas, a unanimous decision by the U.S. Supreme Court in the area of the Voting Rights Act, Section 5 of the Voting Rights Act, which puts a certain number of states, including Arizona, into what I call a penalty box, where you have to have any changes affecting voting pre-cleared by the U.S. Department of Justice. That means even if the Department of Motor Vehicles changes its hours, because DMV has voter registration, that has to be pre-approved by the United States Department of Justice, a law that has long since outlived its emergency utility, and a utility district in Texas challenged this. The court, 8 members of the court said, this raises really, really serious issues of federalism, but we're going to allow this district to opt out, essentially, from the coverage of the law. So another decision in terms of state autonomy. The employer sanctions case, the U.S. Supreme Court upheld Arizona's employer sanctions. The list is quite impressive in terms of the latitude that the court has given the states. This is an area in which the Goldwater Institute is very, very deeply involved, and I'll just mention the cases that we're involved with very quickly. I mentioned the Healthcare Freedom Act before. That is currently in litigation. It will be interesting to see what the court does with that. One of Judge Wake's other colleagues recently rejected the NLRB's facial challenge to another constitutional protection that was drafted by the Goldwater Institute and approved by the voters, Save Our Secret Ballot, which protects the right to secret ballot in organizing unions. And the NLRB came in and attacked that, and the facial constitutionality of that was sustained. We represent the town of Tombstone in a case that some of you may have read about. Tombstone has relied on a certain water supply for over 100 years that is now part of Park Service land. The hurricane came in, destroyed the pipes. The town went to go repair the pipes, and the Forest Service said, sorry, we're not going to let you onto federal land to repair your pipes. As a result, Tombstone now has to use a water supply that has 10 times the arsenic level allowed by the federal government, and it doesn't have enough water to put out a fire. This is in litigation in the Ninth Circuit, and we will team up with the Arizona Attorney General to challenge Section 5 of the Voting Rights Act on constitutional grounds as well. So lots and lots of federalism decisions coming up. In this case, the SB 1070 case, I think it was an unusual situation where Congress does have, despite Justice Scalia's dissent on this point, express constitutional authority to regulate. It has regulated very, very extensively, and as a result, the court upheld these provisions. But this bucks the trend of the court being very, very solicitous of state activities that collide in some sense with federal law, and I suspect we're going to see a lot more of that. Thank you.
Would you just give me the, your equivalent of the red light in 8 minutes so that there's 15 minutes for questions? And I'll apologize in advance. I'm going to need to leave about 10 minutes before this is over in order to make hopefully make my flight. I think that it's fair to say, and I think everybody would agree, that the Supreme Court's ruling in the Arizona immigration case was certainly a resounding reaffirmation of federal primacy in the area of immigration, whose authority Justice Kennedy right off the bat says resides both in the power to make uniform rules of naturalization and also the exclusive foreign affairs power of the federal government, not just the naturalization clause. I litigate a lot of preemption cases and a lot of preemption cases in the United States Supreme Court, and I think this is quite a muscular preemption decision, no question about it. It's resounding because the foremost champion on the current Supreme Court of principles of federalism, time and again, is Anthony Kennedy, who was the author of this opinion. And that fact does, I think, warrant scrutiny in terms of what is going through Justice Kennedy's mind and Chief Justice Roberts' mind in making a very solid majority for the rulings in this case. I think, first of all, there's a sense in which, yes, as Justice Scalia points out in his dissent, there is a lot of authority for the proposition that at the founding, the states also had immigration and immigration enforcement authority, but that doesn't really answer the question of whether when Congress enacts a law, and enacts a law that quite, as Justice Kennedy points out, quite self-consciously delegates a lot of enforcement discretion to the executive branch, in the face of either an expression of field preemption in a particular area of immigration enforcement, which the court found in this case to include alien registration, or conflict preemption, that is, which is to say either that the federal law and the state law can't both be complied with at the same time, which was not at issue here, or another form of conflict preemption announced in Hines versus Davidovitz, which was what's called frustration preemption, that is, where the operation of state law would frustrate the full objectives and purposes of the federal legislation. I spent a lot of years litigating preemption cases on behalf of the United States, in which we kept arguing that various state provisions or local provisions were frustrating the operation of federal law without getting anybody clapping in the audience. And people started to wonder whether there really was such a thing as the branch of conflict preemption known as objects and purposes frustration preemption. One of the cases I argued in the Supreme Court when I was Solicitor General was a case that turned out to be called Crosby versus the National Foreign Trade Council, and here's what it was about. Somewhat akin to all sorts of ordinances enacted by random municipalities in the United States, such as Berkeley, California, Cambridge, Massachusetts, Tacoma Park, Maryland. The state of Maryland, which had announced all sorts of foreign policy initiatives and prohibitions and objectives, including many, many initiatives to prohibit the use of any local public funds, for example, on companies that were doing business in South Africa during the era of apartheid, which the federal government opposed. The state of Maryland decided to pass a law that said that no company which did business in Burma or that had any subsidiary or sister company that did business in Burma or did business with any other company that did business in Burma could obtain the benefit of any federal contracts in the state of Maryland. And it was challenged on constitutional ground, preemption grounds, by the National Foreign Trade Council, and because of the obvious importance to the federal government, we participated. I argued in the Supreme Court that this was completely, it was demonstrably frustrating the objects and purposes of Congress, which had been announced repeatedly to be the best way to change the repressive regime in Burma, as prior administrations had thought was the best way to change the apartheid regime in South Africa was through engagement. And the record in the case demonstrated that there were foreign ministers of other countries that were making visits, official visits, to Boston, Massachusetts, Sacramento, California, and Annapolis, Maryland, to try and convince these sub-national bodies to have a different, quote, foreign policy. And the United States government, the national sovereign, actually does have textual exclusive authority over foreign commerce and relations with foreign governments. And the spectacle of having these foreign ministers go to Annapolis was more than I could stand in any event. And I argued this is frustration preemption. It seemed like a really straightforward case. Well, we ended up winning in the Supreme Court, but not on frustration preemption. The court looked at some non-binding resolution that some Congress had once passed that said something like this, and it's called this express preemption, which it wasn't, but I think it demonstrated, telegraphed to all of us in the federal government how reluctant the Supreme Court was to find that state or local laws frustrated a congressional object. And yet, that's exactly, with respect to two of the three provisions that were struck down, that's exactly what the court did here. I think it has a lot of implications in the immigration, the sort of local immigration initiative beyond the geographic confines of Arizona. There is legislation or municipal ordinances on the books and other places that make it a crime for undocumented aliens to obtain public housing, to attend state, public educational facilities, and I think all of those things are now fair game for preemption challenge under the breadth of this court's objects and purposes ruling. I think there really is something insightful in Judge Wake's observation about what exactly is being frustrated. Is it the legislation, or is it the executive's means of discretionary choices in how to marshal the federal government's admittedly insufficient resources to deal with the massive problems of illegal immigration in this country? And I think it does explain to a large extent the difference between the approaches taken by two otherwise natural allies in federalism and preemption debates, Justice Kennedy and Justice Scalia. Justice Scalia says, look, I'm not arguing that the Congress can't pass legislation that under the Supremacy Clause preempts. Yes, I got my stop sign. But that's not what's going on here. What's going on here is a lawless president, so-called president, who is making all sorts of unwarranted choices. What Justice Kennedy says is this is all about preemption by federal legislation, but he points out at the very beginning of his opinion, a principal feature of the legislation is the broad discretion exercised by immigration officials. So they're seeing the federal government's action in this way in two very different ways. And it will be interesting to see how this plays out more generally in not only the immigration enforcement area, but preemption generally.
Wow, great panel. I can't tell you how much I've learned today. I want to thank all three of you for your contributions. It's absolutely outstanding. We have time for a few questions. If we would try to do not the five-part question, the one-part question, and let me know to whom it's directed. And we'll do what we can, and then I will be cruel, very cruel, and just stop it at 4 and feed you out there. So that's not so cruel, right? Okay. Chris?
To the extent the question is to be directed, let me direct it to Mr. Block. On the Medicaid expansion issue, I don't know in what sense it would be intolerable for a state to lose Medicaid funding, because here in Arizona, we slosh people in and out of the Medicaid program every year, depending on the budget cuts, $100,000 people at a time. But does this ruling suggest that maybe the federal government can't ever stop Medicaid? That, I mean, even if it was unconditional, if we had an administration that wanted to shrink the role of the federal government considerably, are we now in a situation that the federal government spending is a one-way reaction?
I would say the answer to that is no, because the predicate for striking it down was coercive action toward the states, and if the federal government simply said we're not going to do this anymore, and it was not accompanied by a demand that the states do something different, then you would not have at least that factual predicate.
Just a very quick question. This is to the entire panel. What's your opinion on what Scalia did in his dissent? I mean, it was just kind of so out of the blue. And this is the guy who gave us Crawford versus Washington. I mean, this is like it seemed like we saw more of him in this dissent than we've seen in other opinions. And I just want to see what you guys thought of this dissent.
Well, in some sports competitions, they give 2 scores, 1 score for technical merit and another score for artistic impression. I do not score style, so I'll pass it. So
I'll make one comment because I need to run out. The thing that really struck me about it, and it was exactly the same thing that struck Clint, I couldn't believe when I read this that Justice Thomas wouldn't join. And it suggested to me that there's there may be some questions about the conclusions that he draws from his originalist sources. Because, I mean, reading the opinion, one would never mistake the verbiage and the style for Justice Thomas, who was always very measured and very careful. But the fact that this was, an originalist interpretation that was not joined by Justice Thomas was the kind of reaction I had where, if this was an area that I was going to continue to be involved in, I would want to check the math. Anyway, thank you all very much. Sorry you're going out. I wish I could stay.
I don't have much to add to that except that Scalia gets piqued every now and then, and clearly he thought that Arizona had a very, very compelling reason for doing what it did, and that the federal government had completely abrogated its statutory responsibilities, and so he came out swinging, as he occasionally does.
It's not so much a comment to that question directly, but one can see the problem here that the Immigration Reform and Control Act, I think, in 1986, basically did a significant expansion of federal preemption on employment and other things. And there's a little bit of the look of not honoring the truth in legislating clause that does not exist in the Constitution, because they preempted it and then didn't do it. So you can see the frustrations, and maybe Justice Scalia was feeling some of that too.
Judge Houghton?
Yeah, over my career, and Judge Wake's done it too, we've always decided what probable cause was. What do you think reasonable suspicion is?
Well, that does have some safe harbors. If you got an Arizona driver's license, you're okay, and some other things. And the law enforcement people deal with, we see them in our court all the time. That's the volume of our criminal cases where they have these stops all the time. And typically they stop somebody, they don't speak any English, they don't have a car registration, right, that's enough to do something. They don't have an Arizona driver's license. So most of these look very easy to think, maybe that person is not lawfully in this country. Now, borderline cases, I don't know.
Don't you think that'll be litigated a bit?
That it'll be litigated in state courts on an as-applied basis. So.
That's what I was afraid of.
Right.
Professor Weiss?
Pretty safe bet.
Yeah.
Let me pose a very short hypothetical. Let us assume the administration initially proposed a single payment plan. After a great deal of debate, Congress, broad bipartisan support, adopted legislation available to the Affordable Care Act. The Supreme Court challenged on the same grounds. Do you think we would have seen the same opinions and the same votes?
I think that would be a no-brainer that's within Congress's power to do that. What do you think?
No, wait, I just want to make sure I've got
Single
your
payer
hypothetical.
system.
But you said started out with single payer and ended up with the affordable?
The initial proposal was single payer. After a great deal of debate, was bipartisan agreement on something identical to the Affordable Care Act.
Oh, I misunderstood.
And it was challenged on the same grounds.
I don't think that would have made a difference. One thing that this court has distinguished itself with is not caring whether it's a Republican idea or a Democratic idea or a bipartisan idea, by and large, with one major case exception, I should say. But the fact, for example, that the Bush administration was, in the federalism cases I mentioned before, on the Oregon law, didn't seem to affect the outcome in the slightest. So I may just have a rosier view of the integrity of the Supreme Court than is justified, but I don't think that would have had that would have affected it. One thing that I do think may have given the court some strengthening of its convictions was the fact that a majority of states supported overturning the law. And I think the court doesn't like to go too far out on a limb. I thought that that was a very, very shrewd strategy by the opponents to round up an outright majority of states to support the challenge.
I misunderstood your question. I thought you were asking about a straight single-payer system.
One more? That's how good this panel was.
Thank you very much.
I just want to give a special thanks to Professor Massaro. It takes a huge amount of preparation to be able to get up here and do what she did. And thank you, thank you, thank you.
Yes, it does.